Any mention for urgent matters? Any mention for urgent matters?
Take a chance, imagine. It's 10:30. Yes. Yes.
Any mention?
May please, Your Lordship.
Yes.
Your Lordship, I beg to mention item number 41, Your Lordship.
Number?
Number 41, Your Lordship.
They are number 41 today.
Yes, Your Lordship, 41.
Lack of fact matter. Lack of fact matter.
The conducting council is indisposed, Your Lordship. So I pray
Who's
that
the
matter-
conducting council?
Mr. A.G. Mohan, Your Lordship.
41.
41, 42 and 43 are connected, Your Lordship.
On behalf of respondent number 4, Your Lordship.
Mr. Yobin is not here.
It's on legs, Your Lordship.
41, 42?
42 and 43, Your Lordship.
Okay, after 2 weeks, yes.
Highly obliged.
As the conducting council stated to be indisposed, yes. Yes.
May I please, Your Lordship, I beg to mention item number 47.
40?
47, Lordship.
Priti Bala.
Yes, Lordship. Yesterday we filed the rejoinder affidavit.
Yes?
We finished the rejoinder affidavit.
I cannot hear you.
Yesterday only we finished the rejoinder affidavit, Lordship.
Then it's ready for hearing? Ready?
Oh, Your
We'll have it
Lordship.
today.
No, Lordship.
Why?
Some more time.
You are there. You know the matter, correct?
Did it come after 2 weeks, Your Lordship?
Why?
They just filed the regent affidavit yesterday only, Your Lordship. So we need some time.
Okay, to giving, you should argue, or junior should argue. Doesn't mean that will be disposed, but take a chance, yes. 2 weeks.
Your Lordship, I beg to mention item number 45.
Why? What reason?
The conducting council is out of station.
Who is conducting council?
ASCDK.
No objection, Your Lordship.
2 weeks.
Obliged, Your Lordship.
Yes, call out.
Supplementary list, item number 1.
May it please, Lordship. Lordship, I have a very limited prayer in this case. Here the
Hidayatullah Qazi.
Qazi, because the governing body, at present there is no governing body in the college. So we constituted a governing body, we have sent to the NEHU, to the director, and he has forwarded to the director. The director is
Which
sitting over the matter.
Forwarded to whom?
To the director, higher technicals, for approval.
Of your governing body.
Approval. And
Of your
director
governing
is
body.
governing body, yes. So the director is not giving the approval, though the as per the annexures,
Has he rejected it?
annexure 80.
Is it rejected?
No, it's not rejected. There's no
Then?
taking a decisions.
When was it sent for approval?
It was sent on 16/6/2023. We have written to the director. The NEHU has written to the director after inducting 2 more representatives from the NEHU. And this director still has not given the approval, and the reason has not been assigned by the director. What is the reason for not giving the approval? Suppose if the director gives some reasons for not giving the approval, it is submitted by the principal, and thereafter it has sent to the NEHU, and NEHU has given to the higher technicals.
Yes.
So if
Who's
it can be
appealing for whom?
disposed of, Lordship, with the direction to consider it or to dispose
Will
it
it get
of.
instructions first?
I'll have to take instructions.
Yes, heard Mr. M. Kurishi, Leader Council of the petitioner. Issue notice.
Lordship, this is a matter to be disposed, praying for disposal, but in a short date.
Do 1 week, let him get instructions. Mr. Khan is present on behalf of responsible 2. And as the question involved in the matter is very limited with regard to the non-approval of the reconstitution of the governing body of Qazi and Zaman College, which had been put up, which had been sent to the respondent number 2. Since 16/6/2023, Mr. M. Kurishi's 2023, In spite of the request being made by letter dated 6/6/2023 by the Northeastern Hill University staff, and paragraph, Mr. Khan to obtain instruction within 1 week. This on today is the 24th. This on 31st of this.
Highly obliged.
Item number 2.
My lord, the grievance of the petitioner has been redressed, my lord. So you can.
Correct.
No idea.
Why acting so surprised?
My lord, I have the petitioner has not.
The impugn order has been recalled, my lord.
The transfer.
No, my lord, that voluntary retirement. My lord.
Voluntary retirement.
Already cancel this. Yes. When the matter has been taken up today, Dr. N. Mozikalana, DGSI, has produced a communication dated 21st August 2023, which records that the voluntary retirement order in respect of the petitioner has already been cancelled by the record branch. So the same mistake, the said communication is taken on board and made part of the record stamp. Therefore, in view of the development, nothing suffices for the conclusion of the petition, and the same disposed of instructions is.
Highly obliged.
Item number 3.
Is it correct?
But this matter, there is some complication, my lord. My lord, what happened, my lord? Before the order was passed by this honorable court, my lord, because the other person is BSF to BSF transfer, my lord, that is not an interforce transfer. So what happened, because BSF has not been made a party in the petition, nor the other transferee, the other doctor who has been transferred is a party here. And because this order was not communicated to them, because they are not open party, my lord. And in the ignorance of this, my lord, the joining has happened, my lord.
So what are we to do now?
My lord, what I would pray, my lord, we'll file a short affidavit, matter can be finally heard and disposed of within 1 week's time, my lord.
Well, Lordship, actually, this is a...
Because the other doctor has to be unseated now, my lord.
And Lordship, they cannot say that they have not been informed, because I have sent an email with the order copy, Lordship, attached, and they have received it. After receiving the first order, they have passed, and my legal notice, they have passed the order dated 24/7, Lordship, saying that on 7/7 the BSF have recommended the posting of some other persons. But the court's order was on 31/1, Lordship, 2023, and Assam Rifles has also issued their no objection on 15th of March, Lordship. But the ADG set over the
You do one
matter.
thing, you file, I will drop sumoto contempt.
Lordship.
You are not party.
Lordship, the ADG may be given a personal appearance because he is taking us for granted.
My lord,
And our...
my lord, in my humble submission, my lord, because this was a BSF to BSF transfer,
Doesn't matter.
and these
But
transfer.
if they are aware of the order, whoever they might
Yes,
be,
Lordship, because that was recommended by the ADG
yes,
himself.
you communicated to them.
My lord, if I may just place, my lord, BSF issued the transfer order before the status quo was passed, my lord, and ADG is unaware of that, my lord.
No, ADG has himself stated in the letter that the BSF has recommended it.
Yes.
And then you cannot say he is not aware. And Lordship, my friend also should uphold the court's order, Lordship. He should not...
Of course, first duty to the court as a
My lord, that is why what I was praying, my lord. In 1 week's time, we'll
As
file
an
an
officer of the court.
affidavit. Matter can finally be disposed of, my lord.
otherwise we'll drop sumoto. We'll ask them
1 week's
whoever
time.
they might be.
Lordship,
My lord, 1 week's time, we'll file an affidavit.
everything
Lordship
is
may-
taking time on some other grounds, Lordship. Sumoto contempt may be drawn, Lordship. Otherwise, they will have no respect for this court, Lordship.
Let's see the letter.
my lord.
This one. And I've heard that, Lordship, the person who has joined, Lordship, her husband was also transferred, but once she got, the ADG got my notice and the order, he immediately released her from there, and the husband was released later on from the same post, same place, Lordship.
But this is BSF order. The ADG medical, my lord, has nothing to do with this one.
I can't make out here a deal this one.
My lord, here what happened, my lord? BSF, this is the order from BSF, my lord, and this is transferred from the BSF hospital in Jalandhar to BSF hospital.
Subject writ petition number 260. This is 260.
Lordship.
Yeah, then?
And Lordship, that day when I suggested that they may allow the joining, Lordship had said that Mr. Mojika is there to advise, and I depended on that, Lordship.
Yes, sir. Take down. You file a miscase.
Lordship, for stay earlier, Lordship had passed an order of stay, status quo order.
On 8 my lord, 8th August.
Yeah.
ADG being the head, Lordship, he was required to inform everyone because he has himself approved the transfer.
Now, the order is 31/1/2023 division bench. What was contained there that he had to take a reasoned decision, correct? Within?
3 months, Lordship.
My lord, at that stage, what was the issue, my lord? Because Assam Rifles has not given concurrence to interforce transfer to BSF, my lord. Because this doctor is serving the Assam Rifles.
But Lordship, that was
Pursuant
given.
to that order, my lord, Assam Rifles in the month of March itself, we have given the clearance, my lord. My lord, that is reflected in the impugned order in the writ petition
Last
itself, my
page,
lord.
Lordship, 58.
Page 58 of the writ petition.
That the Assam Rifles have given their concurrence, Lordship, but the ADG did not allow the posting even then. He sat over the matter up to June,
58
July, Lordship.
para 8.
ADG, Lordship.
Who's ADG?
ADG, Lordship. He is the Additional Director General,
Okay.
who is the head of the medical department.
Para 8, lordship, is fine. Para 8, it page 58, my lord, of that person.
Yes.
Assam Rifles is given NOC on 15th of March 23 itself, my lord.
Yes.
So as far as Assam Rifles is concerned, my lord, we don't have any role after that, my lord.
And the ADG is a person from the BSF, Lordship. He does not want us to join. That is why this game is going on.
You can't go behind and look what kind of game is going on.
That I don't know whether ADG is from BSF.
Why is on deputation from cross for deputation also from BSF to Assam Rifles?
Lordship?
The ADG.
I don't know, my lord.
By
There's-
promotion, Lordship, somebody
That's some interview. I
gets that
don't have
post,
any.
Lordship.
The person is from BSF, my lord.
Yes. Other miscase.
Lordship, granted, because the question is of unseating that joining, my lord. So what I was saying, 1 week's time, my lord, we will file an affidavit. Matter we finally heard in any order passed, my lord.
Lordship, and nobody will have respect for this court, Lordship, because they are taking us for granted all the time.
But this happened, my lord, because BSF is not a reddish party anyway, my lord.
But
And even the
Mr.
doctor
Mojika
transferred.
was there, Lordship, to.
That is Director Medical CAPF. Now he's number 4 in the miscase.
He's there, my lord.
Then
He is there. And the Home Ministry is also there. MHA is also there, Lordship.
did you bring this on record orally that day? By verbally, you didn't file any document to show the transfer, correct?
Regarding the.
Regarding the transfer of the BSF.
Lordship, we do not get the.
Right, that's
Yeah,
fine.
Lordship.
That's fine. Yes, sir. Last order.
Lordship, at least to uphold the dignity of the institution, Lordship.
My lord, when BSF is not a party, it was not my duty also to communicate to BSF, my lord.
And by
Pass that kind
by
of
order
live-
21/8/2023, this court recorded the submissions of MS.M. Bodoroy, who had apprised of what that, in spite of the order dated 8/8/2023 passed by this court, directing for status quo be maintained as on that date with regard to posting. Follow some with the order. A doctor, a BSF doctor, had been accommodated and transferred to the post for which the Assam Rifles respondents had issued orders of release for the petitioner to enable him to join the said post. Next paragraph. Today, Dr. N. Mosikala, DSGI, with so-and-so, has produced a communication dated 23rd August 2022, which corroborates the assertion as made by the writ petitioner. Stop. It is noted that in the said communication, one Dr. Bani Saikia Chetia has been relieved from BSF Jalandhar on 11th August 2023 and is reported at BSF Patgaon on 18 August 2023 and joined against the said post. Stop. The instant matter has been a subject of protracted proceedings before this court, inasmuch as even the division bench of this court, by order dated 31/1/2023, passed in writ appeal number 2/2023, had recorded the saga involving the application for transfer of the writ petitioner. Stop. In the said order at para 13, the division bench of this court had recorded as follows. Court in para 13. Next, it appears pursuant to this order, the Government of India, Ministry of Affairs, in the office of the Additional DG bracket MED, after bracket CAPF, then small s, comma NSG, and ER, close bracket, semicolon, have recorded at para 8 of the said letter the release by the Assam Rifles for transfer of the petitioner to the composite hospital BSF Patgaon. Stop. Next, it appears that in spite of these developments and the order of this court dated 8/8/2023, the respondent number 4, is one number 4 here also in the main petition?
Lordship.
Respondent number 4. No, respondent number 4.
We have made him a personal party also.
Yes. Respondent number 4 had shown disregard to the orders of this court, both of the division bench and of this bench. In his view of the matter, the respondent number 4 is directed to file a affidavit within 1 week, clarifying and explaining the actions taken, fearing which suo motu contempt proceedings will ensue. So, this is matter after 1 week on 31st. Too much. Well, you can't plead. Let them come and appear. When they come here, you don't know where they'll go from here. We don't care. It's EDG, anybody.
Much obliged, Lordship.
Yes.
Name is item number 1.
A copy of order be given to the DHCI for instant communication to the concerned respondent. Yes, Mr. Priam.
Your Lordship, I pray for 2 weeks' time. Senior counsel is out
2
of
weeks'
station.
time?
Your Lordship.
He's on legs.
He's out of station, Your Lordship.
It's for admission, correct?
Your Lordship.
Yes, Lordship.
Last time on your accord, now on. What's the matter about? We admitted then?
Your Lordship, this is with regard to the illegal appointment of respondent number 7.
Your Lordship is challenging the election of the Sardar of Yangtze, Lordship. He's not an elector, he's nobody, Your Lordship. That's
You object to maintainability.
yes, Lordship. No senior.
Mr. Kintai, Your Lordship.
He objected. So where's Mr. Kanta today?
Your Lordship, they already informed us, Your Lordship, that we're taking time, so that's why he...
So we should inform the court also before that then? No problem. Since we already took a decision. Yes. Due to the unavailability of the senior counsel for the petitioner, this is matter for 2 weeks.
Much obliged.
Item number 3.
Your Lordship, the conducting counsel, I don't know even
Yes?
which room. The
Take
conducting
other matter first, I'll cover this matter also. What's the other number
Item
4?
number
4, yes. It's connected. Huh?
This is a connected matter. Let's item number 4.
Yes.
On the last occasion, a copy of an affidavit on behalf of the respondent number 1 and 2 had been served on me,
When was it, sir?
It's
16, Your Lordship will see. The order is there, my lord. Order clearly says that the comp. Yeah, I don't know. It is. That is the order sheet.
it was on 16th.
Okay.
We are in the process of filing a rejoinder to that. That is on behalf of respondent number 1 and 2. But respondent number 3, that is the Deputy Commissioner, if I may draw your Lordship's attention to the order dated 9/8/2023. That was when the matter was initially moved before your Lordship's.
Yes.
The second page, if your Lordships have, Mr. So-and-so learned AG appearing for the respondent number 3 submits that the matter requires an affidavit to be filed by the respondents to bring the entire facts on board. The matter may be taken up after 1 week, and he further submits that no course of action. So, respondent number 3, still today has not filed any affidavit. Respondent number 3 is the Deputy Commissioner who has passed the order.
Quasi-judicial authority, my lord. It's a quasi-judicial authority, and the order has been passed under under the Public Premises Eviction Act in quasi-judicial capacity, my lord. So once it's a tribunal.
Okay, so tribunal type, so appeal will lie.
Tribunal. So therefore, whatever records. This is all dilatory tactics, my lord. The lease has expired in 21, and they did it before.
I go out for 5 minutes through PC. My learned friend says I'll file an affidavit, no course of action for 1 week. Affidavit not filed and dilatory.
I was arguing the matter, my lord. Affidavit was filed. I was arguing the matter, my lord. I have no issue because
Monday.
Monday, very well. This affidavit we are filing in the course of the day. Your Lordship,
we have it on Wednesday. Monday there are so many matters listed. Wednesday.
Yes, Mr. K. Paul Leonard, Chair Counsel for the petitioner, submits that the rejoinder affidavit to the affidavit response 1 and 2 will be filed in the course of the day. Okay, this is a matter on Wednesday.
I would also pray that let them produce the records. Since they are not filing the affidavit, because here the question is there are 2 orders. Your Lordships would recollect this.
Let's see in the course if the affidavit does not suffice, then it's to the detriment. It's not that you'll help the case by the report. Yes, similar on Wednesday. You filed a jointer, Mr. Chakravarti, to the affidavit.
We haven't filed.
Oh, will you be filing? Not necessarily. His reply will cover. I think it's similar.
See, at least in our matter, there was no prayer by the government to file an affidavit. But I think since these are connected, so if they file, probably
they'll cover your case also.
Cover. And whatever has been filed by the MTC, so that regenerates.
Item number 3. Sorry, item number 5.
Mr. Paul requires rejoinder. Mr. Paul.
Because MTC is seeking to justify the orders passed by the Deputy Commissioner. So what can I do about it?
Item number 5.
You filed a jointer?
Your Lordship, I'll be filing my rejoinder in the course of the day.
Your MSGC Marbo. MSGC submits that you rejoined after you find the course of the day. This is a matter after 2 weeks for hearing.
Lordship.
Item number 6.
We filed the suggested issues, because pleadings are otherwise complete. Your Lordships would have to frame issues.
You filed
Yes, we file our written statement, Your Lordship.
No, suggested
issues not yet, Your Lordship.
Then?
Your Lordship, on the next date we will be filing.
You file an application, you see.
Yes, Your Lordship.
Suggested issues on behalf of the election petitioner have been filed, the same are taken on board.
And for respondent number 1, Your Lordship.
You file it, you can file it in the course of the day, suggested issues.
Yes, Your Lordship.
Suggested issues.
Yes, Lordship.
Because then your Lordship may frame the issues on
Yeah,
the
then we
next.
can frame issues and proceed. Yes, Mr. Emling, correct?
Yes, Your Lordship.
Submits that the issues on behalf of the respondent number
1, Your Lordship.
Will be filed in the course of the day. Yes, accordingly, we'll discuss this matter after
A week.
1 week, yes.
Right, Your Lordship.
Item number 7.
For framing of issues. Yes.
I filed my rejoinder.
So let the matter be posted for hearing, Your Lordship.
Can we dispose of short matter or long
Your
matter?
Lordship.
Yes, ma'am.
But Your
Short
Lordship,
matter, because they have admitted that.
may I please, Your Lordship, it is yet to receive from the government office rejoinder.
That's not my problem. That's not the court's problem.
Your Lordship,
You can file. When was it filed?
Yesterday, ma'am.
Then enough time.
no, Your Lordship, I am yet to receive it, Your Lordship. So let the matter posted for hearing next week, anytime.
Once it goes for hearing, it goes to oblivion.
Look, limited issues, ma'am.
This file is not. Please, Your Lordship. Next week, any day.
Okay, Mr. Akash submits that the joint actress has been filed this matter for hearing after 2 weeks.
Much obliged.
But once it comes for hearing, no adjournment. It's just small matters like this shouldn't be kept pending.
Your Lordship, I am yet to receive from the office.
That is not, don't make the excuse, please. You're a seasoned counsel.
Item
Once
number
it's
8.
filed, it's on record, it's on record.
Item number 8.
Yes.
May I please, Your Lordship? May I please, Your Lordship? Respondent
Yes.
number 4 to 9, they are yet to file the affidavit.
4 to 8. 9 is different. 9 is whom?
Respondent number 9, Your Lordship.
9?
Yes, Lordship.
You're not filing affidavits.
I'm praying for some time, Millards.
Number 9, you are Mr.
We need time for filing of the affidavit.
What's the matter about?
This pertains to the appointment of the respondent number 9, Millards, in the Shillong College, Millards.
Shillong College. You're appearing for the college.
I appear for the college.
Mr. K. Paul and State Council, we have 4 to 8. And your name?
I Kharmujai.
Mr. Aikhan Mujai for number 9. 10?
Your Lordship will not be filing an error.
11. You're filing affidavit.
My Lord, it might not be required. I'll supplement.
Okay, Mr. Kepol for response 4 to 8 and Mr. Sunso for number 9, pray for and allowed 2 weeks further time to file affidavits. MSS Rumthao for number 10 and P. Agarwal number 11 submits that no affidavit forthcoming from their side. Only up to 2 weeks for affidavits. Yes.
Much obliged.
Item number 9.
My Lord, I'm waiting for the petitioner in this
Yes.
matter. Contents are getting filed their affidavits.
You file affidavit? Why? What about government?
Lordship, the preparation is under process, my lord. I pray for another 2 weeks' time.
4 to 2 weeks time granted to the state respondents and response 7 and 8 for affidavit is thereafter and so on. Yes.
Much obliged, Lordship.
Yes, Mr. Dr. Mazika.
As for affidavit, my lord, I'm praying for is done, my lord. Within 1 week's time, we'll file it.
Pension matter?
It's just done.
When he retired?
It's long
85.
Yes,
you
my-
got pension till now?
No, he received the pension during his lifetime and he died, my lord, in 2020.
Oh, you have any pension now?
And his wife is claiming, my lord. Supposed.
Okay. Dr. Mazika, please once allowed for the 1 week's time to file affidavit just thereafter and so on.
11.
Yes, Your Lordship, I'm praying for 2 weeks' time, Your Lordship, to file an affidavit.
Yes, as Shalom, please on behalf of respondents, please allowed for the 2 weeks time to file affidavit.
Item 11 and 12, Your Lordship. Much obliged.
13.
Please receive.
I'm praying for some more time to file the affidavit, my lord. So I'm for the respondent number 5.
13 is? Yes.
Your Lordship, I have received the status upon the service report on the respondent number 4, Your Lordship, and the notice has been served, Your Lordship, and I have already filed the affidavit, Your Lordship, to bring record.
What about government?
Government is not required to file.
MS Adhata for respondent number 5.
This one number 5.
Praise funds allowed further 2 weeks time to file affidavit stuff. Mr. D. Nuta submits that the service on number 4 has been affected and after service affidavit has since been filed indicating the fact of the service. And this is a matter of 2 weeks for affidavit of number 5 and for appearance of number 4. Yes.
Right.
14.
Resolved?
Yes, no, Your Honor.
Not resolved.
But I'm waiting instructions, my lord. It was supposed to be resolved, but try to contact them yesterday also.
Further, Your Lordship, due to the pendency of this case, Your Lordship, the other bills that are entitled to the petitioner, they all block, Your Lordship. So this is causing a great difficulty to the petitioner, Your Lordship. Being a businessman, he needs this money to be moving, Your Lordship.
Interim order is already there. Interim order is already there.
What interim order is there?
No coercive action.
Yes. No recovery is being done right now.
No, Your Lordship, but his other bills are blocked, Your
You said after 1 week, is it correct? It's after 1 week, Dr. N. Mozika submits that no instructions have been received with regard to the resolution process. He prays the matter is after 1 week, they're able to obtain instructions. Stop. Mr. One Sweat,
Yes.
next by Mr. One said has also submits that in view of the pendency of the instant matter, the other pending bills of the writ petitioner have not been cleared. Dr. Muzika to look into this matter obtain instructions. Yes, on so.
15.
May I please,
You haven't filed affidavit till now.
Lordship, we have prepared the affidavit, but we are seeking further instructions, Lordship.
Why?
There is some clarification required.
Where is he posted now? He is here only, correct?
Yes, Your Lordship.
We'll just give you 3 days more time. Why next week affidavit should be here?
Lordship, kindly, Lordship, 2 weeks' time.
No.
3 days is too short, Lordship.
Okay, 1 week.
10 days' time, my Lord, kindly.
One week is enough. The affidavit on behalf of the state is that you're on board. Stop. As the matter is it pending since? When was it filed? Okay, no, doesn't have to matter.
June, Lordship.
Yes, you're on board. Stop. MS NG shall have to respond allowed for the 1 week's time to file affidavit. Please.
Lordship, this matter was filed in June. I pray for 2 weeks' time, Lordship.
16.
Much obliged, Lordship.
Please, Your Lordship, I am praying for 3 weeks' time, Your Lordship, to file an affidavit.
Counsel, what last time? Correction been made?
Yes, Your Lordship, we have made necessary correction.
Yeah, Bisun.
Yes, Your Lordship.
MS Bisun, counsel for the petitioner submits that the correction has since been cause title indicating that the registrar's pen number 1 stop. And for MS Salam's vice, Mr. S.N. Salang counsel for Nehu prays for the 2 weeks time for
3
affidavit.
weeks' time, Your Lordship. 3 weeks' time.
2 weeks enough. As
17.
prayers allowed, it is after 2 weeks.
Milord sir, granted me time to file a reply to my learned friend's affidavit.
The case I am praying for stay, my lord. What has happened that the order has been passed by the learned MSCRC saying that the matter was heard on 4th.
Heard on?
On 4th July 2023. Heard on 4th July 2023. Our case is that the matter was not heard, it was not taken up. The date was given for hearing their review stay application, my lord. That we have made the averment in our affidavit, but on 11th July, my lord, impugn order came to be passed, saying that the matter was heard on 4th July. Your Lordship, in the wake of my allegation, my lord, if Your Lordship will see, in the wake of my allegation, my lord,
yes.
Lordship directed the respondent to file affidavit to the said effect, my lord.
Yes.
We have filed the affidavit to the said effect that on 4th July, matter was not heard, and the same has also been reiterated in my petition, my lord. Kindly see paragraph 2 of my petition at page 17.
Para 2.
Para 2.
Page 17.
Yes, paragraph 2, my lord. That the order dated 11 July passed by the learned chairman of the respondent, Meghalaya State Electricity Regulatory Commission, in IA number 1 of 2023 in MSCRC review petition, review case number 9 was passed without affording the opportunity of being heard to the corporation. That white notice dated 3rd July, MSCRC has listed the case, Your Lordship may kindly mark, 1 to 10 of 2022. However, on 4th July, IA case number 1 to 10 of 2020 was taken up for hearing. On being objected by corporation, MSCRC has agreed during the course of hearing to fix the matter on some other day and further granted time to corporation to file counter affidavit to additional affidavit filed by Birnihart Industries Association on 3rd July. However, to the utter shock and surprise of the corporation, MSCRC, by the order dated 11 July, passed an order on the matter which is not even taken up for hearing in the case number 1 to 10 of 2023 and tagged along with the matter number 1 to 10 of 2022, and it goes on to record submission which has not even been made by corporation during the course of hearing. Said act on the part of MSCRC is in violation to so and so. My lord, matter, and kindly see the affidavit, additional affidavit. We have said
other allegations, my lord, but I am right now confining to page 7. Your lordship will see page 7 of my page 7 of the additional.
Yeah.
Page 7, my lord, paragraph K. Lord, page 7 of the additional affidavit, my lord.
Yes.
On 4th July, matter having IA number 11 to 20 of 2022 were listed for hearing. Hearing was being conducted by single member and legal consultant. What is happening, my lord? Legal consultant who is former member of the MECRC, he is conducting the proceedings.
Who was the legal consultant?
Legal consultant was the former member of MECRC.
So what's his name?
Law member of MECRC whose term is over, but still after his term is over,
what's his name?
His name is, my lord,
Kissing, Mr. Kissing. He's Mr. Kissing.
Roland Kissing. And he is conducting the proceeding, my lord.
How?
This is what happening, my lord. The petitioner specific.
Do they have any recorded proceedings?
Yes, your lordship. I have said so.
I think it's recorded.
Yes, your lordship. I have said so in the affidavit, my lord.
It is recorded.
The petitioner specifically submitted the review is not listed on 4th. Recognizing the petitioner's submission, the chairman specifically replied that they are not hearing the review petition and review petition will be listed at later date. Video recording of hearing is being submitted. I can place it on, my lord, on pen drive, my lord. Yeah. Pen drive. I can place this video recording, my lord, and I have seen it, my lord. So this is the way whole process is being violated and stay is being granted. So I was praying, my lord, your lordship is seized with the matter. I was praying that till the time your lordship is seized, at least proceeding before the MSCRC may kindly be stayed, my lord.
Three things.
And one more thing, my lord, the single member can't conduct because your lordship has already held
Very
here.
disturbing, Mr. Paul.
Well, it's three things.
You can't subvert. I mean, whoever the member is, he can't subvert the system to this extent.
No, my lords, I will come back to whatever has been submitted before your lordship.
It was correct that the matter
this
was hearing that day and orders were passed. That is.
My lords, the matter has been heard. I have argued the matter at length.
Before the commission?
Yes, my lords, I have personally argued the matter at length.
Your lordship, I have
the additional affidavit. The additional affidavit filed by the corporation is on record.
We have on email also, my lord. We can send the
let them produce the videos, my lords. If your lordships recollect, my lords, if you finished, if your lordships recollect, my lords, this matter is the matter where I had initially pointed out that writ was not maintainable. Then your lordships, a submission was made before your lordships that the procedure is not being followed before the commission, which is why your lordships had permitted them to file this affidavit. And my lords, in the last order, your lordships had permitted, after they filed the affidavit, your lordships had permitted me 3 days time to file a rejoinder to this affidavit. What I was submitting at the initial stage before my learned friend was opening up the arguments, my lords, because of my personal unavailability in Shillong, that affidavit could not be filed. We will file it and have a copy served on them by Monday, refuting whatever they say. That's number one. Number two, my lords, insofar as the allegations are concerned, this matter is that electricity matter, my lords, which was dealt by your lordships in the first occasion. That special tariff matter.
I will deal with.
So what your lordships had done is, my lords, your lordships had said that they cannot unilaterally withdraw that because there was an order of the commission. They challenged that order before the division bench, saying that High Court cannot decide this matter, it has to go before APTEL, if at all. Division bench took a view, my lords, that yes, High Court will not interfere. This is the same case. How can you make how can you make the submission? How can you make the submission? That order is on record.
I will argue my case, my lord.
That order is on record.
All misleading statement.
This order is on record.
Doesn't mean the court be misled.
All misleading.
My lords, I take very serious exception to this.
No, please.
My simple submission
my lords,
is, my
if your lordships may say, I will just very quickly take your lordship. My lords, I will just take their writ petition.
General, don't worry, the court knows what to do. It's not a question that whatever is being dished out.
My lords, may kindly have Annexure 7 page.
No, just continue.
No, Annexure 7 page 260. I take very strong objection to the Advocate General of the state making these kind of statements.
I am Advocate General of the state and I am making correct statement.
Please look at page 260.
Okay. Don't need.
My lords, may kindly have page 260.
Listen, please. Before we proceed further, an even keel, please. Yes. Right.
My friend probably knows, my lords, that agitating me would divert the matter somewhere else.
That's all part of advocacy.
So what I'm saying is, my lords, they challenged that order before the division bench. Division bench says go back to MSARC, MSARC will hear the matter and pass appropriate orders. We go back to MSARC, we file an application, MSARC passes an order on 5/12/2022. They challenge that order of 5/12/2022 before the division bench of this honorable court. Division bench says, writ court does not have jurisdiction, you have remedy of appeal, please go and file an appeal.
Subverting entire process.
Then
they challenge the order passed by the division bench of this court before the Honorable Supreme Court. Supreme Court says, we will not interfere, you have the liberty of going and filing an appeal. They do not file an appeal. After all that, my lords, now these kind of allegations are being made against the commission. Or commission is doing this, commission is doing that, commission is doing that. What essentially commission is doing is reiterating the order of 5/12/2022.
Okay.
Which is why, my lords, I had, which is why, if I am not finished, if I am not finished, let me finish. Let me just finish. First question is, my lords, once there is an order passed by a division bench of this court that writ does not lie, whether in the face of that order, my lords, which stands confirmed by the Honorable Supreme Court, this writ petition is maintainable. I had raised the first objection on the first date of hearing.
See, Mr. Paul, another thing is that, see, divorcing or like, we'll keep those facts aside now, their ground here is that now...
Orders are being passed without hearing them.
We supervisory jurisdiction under 227 over any tribunals there. Correct.
My lords.
Now we can even, like, it's discretionary. Now if materials are brought for the court that, that prima facie show, and
I bow down.
Then, of course,
that's the law.
I mean, there's nothing that can stop
that's the law.
court from deciding powers.
That's the
only
law.
thing. What they're trying to show now is that whether they can show that kind of irregularity or illegality, right, which is perverse, which has
shake the conscience of the court to it.
So that if they can establish that, then yes. If not, then that's all. So you don't even need to take
we are officers of the
regarding review or regarding. So that's all.
My lords, then therefore the question when my learned friend says, my lords, that is a different matter. Your lordship's order is at page 260.
Say that the matter was heard on 4th July. He is not saying entire argument. He is not saying, my lord.
Mr. RP General. Yes. That is what this court is separating that entire whatever dispute you have
into
the proceeding for tribunal, because superintendence is what to see that if some course correction is needed. So if course correction is needed, then orders will be passed. You're not touching the merits of the case.
Absolutely,
that's all. Then,
which is why my lord said in the first place,
what he is trying to say, he is not.
You filed the affidavit.
He is not
because the lordships were not inclined to interfere.
Yes.
Then, my lords,
now he knows that your lordship was not inclined to interfere.
My lords, if I may finish,
that is the my friend is drawing.
If I may finish,
yes,
that's when the learned advocate general made a submission, my lords.
I made number of submissions.
That the procedure is not being followed before the commission, and your lordship said, if that be the case, you file an affidavit. They file the affidavit.
Let them establish that.
I will place the video.
Let them produce the video recordings, my lords. In the meantime, on Monday, I will file my affidavit.
Your lordship, I was praying, my lord, that in the meantime, what they are trying to get the matter disposed of. No, in the MSCRC. So that all these IAs become infructuous. I was praying, my lord, that till the time
I was not praying for. My lords, it is on record that they are pressing for disposal.
See, okay, take down. An additional affidavit has been filed by the. It's already recorded.
It is already.
Mr. K. Paul, senior counsel appearing for the
respond number 2, my lords.
Number 2 submits that due to unavoidable circumstances, the reply affidavit to the additional affidavit filed by the petitioners has not yet been filed. He prays him without 3 days' time, and that the matter be taken up next week to enable him to file the said reply affidavit stamp. Next paragraph, Mr. A. Kumar and AG appearing for the petitioner has very strong objections and submits that by asking for time, the respondents number 2 seeking to expedite the proceeding before the MSERC, so that the
my lords, the matter before the MSCRC is fixed on the 28th. Your lordships will hear us before that. Have it on Monday.
Your lordship, I am praying that in the meantime they may not, because they have been passing the order behind my back. And this, your lordship has been seeing.
My lords,
they have been passing the order behind our back, and this has happened.
My lords, this is very unfortunate. They are always represented. They are always represented. You cannot make this statement.
No, you file your affidavit, state an affidavit. So, you know, it will be properly sworn.
Problem is, this statement will be backtracked on the next day. I've never made that statement.
See, so the second part, Mr. Kumar cut it out. First paragraph.
Let the proceeding may kindly be stayed, my lord. I know that.
My lords, I have very strong objection to that. Matter is fixed on 28.
Because
your lordships the record matter is fixed on 28. Your lordships hear the matter on Monday.
Thoughtfully. Even keel. Reply to the action affidavit could be filed in time. He pays his time, and that the matter be listed next week to enable him to enable the respondent to file the affidavit. Stop. This court has considered the prayer of the Learned Senior Counsel as the matter has some urgency. Previous times allowed for the reply affidavit, and the matter shall appear on Monday. Stop. As there are apprehensions been expressed by the Advocate General about the proceeding before the MSERC.
It's fixed on the 28th.
Yes, and those informed, and it is however informed by the Senior Counsel on behalf of the respondent number 2 that the matter is not due to come up till 28th. In that view, the matter, this is the matter on Monday.
Exactly.
Let appear Monday.
Let the matter be heard and disposed of on Monday.
On Monday.
And your lordship, with this the pen drive, my lord, we will hand over the pen drive.
Whatever materials Advocate General also permitted to produce whatever material necessary in support of his case.
If they are kind enough to give me a copy, at least they have access, I don't.
I can email it now.
Send them a JPG file.
The all 17 to my lord.
We'll finish it off.
26.
72 to 26. These 10 matters.
27. 27.
Inquiry is over, Mr. Shulai.
Your Lordship, I don't think the inquiry has.
Yes, Mr. Paske is over. You appeared in NPCC, correct?
We have participated, Your Lordship, and then the.
No, court wants to know whether it's over or not your participation. Is it over? The inquiry?
Once that is over. That's my instruction. South Carolina.
Lordship will seek instructions of what the state is concerned, whether the inquiry has been completed.
Where is Dr. Malin? What instruction do you have?
From our part, we've not received any instructions or status regarding the inquiry.
How can you make these matters just... How many matters are tagged together?
Lordship, these are
14 matters.
27 to 40, Your Lordship.
You're hearing it one?
40.
No, can you give any
40, Your Lordship.
prediction or some positive kind of reaction as to whether the inquiry at what stage it is, or whether?
Lordship had granted 8 weeks originally.
Yes.
And spoken to Mr. Muzika, he hasn't received any information. Unofficially, he said that it might have been over, and there is some issue with.
That is what exactly we. The court needs some. We have to have some predictability as to where the matter will go. What to do?
It will come after a week, Your Lordship. That will.
Mr. Paske will be the best person. He's NBCC to give. One portion is over or what? Or what do you say?
The inquiry is done. Only except for one step, it is southwest.
I think you file a status report. Yes, this matter has appeared today. Has appeared today after 8 weeks since 28/6/2023. Stop. It's been submitted by the councils for the parties that portions that the inquiry may or may not have been completed. From this view of the matter, if the same is not complete, the respondents number 1 to 4 who will file status report.
Lordship, the Union of India.
It was at the instance of the Union.
If that is so, the respondents 5 to 8, 14, 15 shall file a status report with regard to the progress of the inquiry before the next date. 5 to 8, 14, 15 before the next date. Just a matter of the 3 weeks.
All right.
Hearing, supplementary list, item number 4.
Act, Surface Act, the Discovery Act.
The limited issue of this matter is whether, my lord, on a closure of written statement, the matter stands ex parte against a person who has approached a particular court or a tribunal. Straight away, my lord, I'll take your lordship to the order dated 31/7/17.
21. Yes.
So the case is called out, if I may read, my lord, the annexure is annexure 1, page 21. And this is the order which we are...
So why are you going back there? Now, according to your own submissions, last time you said that a recovery certificate has been issued.
Yeah, that is reflected in the order, my lord. They have clarified that it has been issued but has not been
issued. That means the entire matter has gone over.
Correct, my lord. But
that means final orders have been passed on the OA or IA or whatever.
On the other date, my lord.
When was it finally disposed of by the Debt Recovery Tribunal?
Lordship, this final order was passed on 5/12/2017.
The final order is 5/12/17.
Yes, Lordship.
So did you ever file appeal against that, Mr. Thapa?
Page 30, page 33.
No, that's okay. But where is that order expired?
Lordship, in the last date, we have just referred to in page 11, para 16. They say that this sections 20 of the Debt Recovery Tribunal of the Bank and Financial Institutions Act 1993 provides for the rights of appeal. The petitioner submitted the same would not be efficacious remedy.
What are you reading, Mr. Das, from
there? Para 16, page 11, Lordship.
Yes.
So there is in this tribunal, this appellate tribunal, from the appellate tribunal, then will not get this efficacious remedy. So that is why they have taken a time to satisfy the court why they will not get the efficacious remedy from this appellate tribunal.
The issue, Millets, here was that the closure of the written statement and the matter proceeding ex parte as against the petitioners, Millets, that your lordships have seen. Why it is not efficacious is, Millets, the moment you go in an appeal before the appellate tribunal, Millets, we are required to make a deposit of the decretal amount before any kind of...
What's the decretal amount?
This final order is how much?
35 crores, Lordship.
35 crores?
35 or 31 crores something. So Lordship, only 25%, not the entire amount.
25% of 35 crores, Millets, on the issue of my written statement being closed. And Millets, we were before your lordships only on that limited issue that law is no longer on this.
The thing is that, Mr. Paul, after it was closed and finally closed, I mean, you're not allowed to file a statement. You didn't. What happened after that?
The matter on that same order, Millets, it says the matter proceeds ex parte against me.
And then when after what is the time gap between the rejection of filing a statement and the filing and the hearing of the matter ex parte and filing of final orders?
The order was passed on 5/12, Millets.
Lordship, first order was
27/1/17 is the first order, Millets.
27/1/2017. Almost 1 year, Lordship.
No, it is not that, because after that, Millets, a review was filed. I'll give the dates, Millets. The first
You
order
can
was
give the
passed.
dates, yes.
Millets, the first order was passed on 31/7/17.
1 second. First order closing your statement.
Millets. And matter proceeding ex parte against me.
That was on
31/7/17.
31/1.
7 Millets. 31st of July 2017.
WS close.
Ballots.
Then
thereafter, Millets, matter written statement closed, matter proceeds ex parte against me.
Okay.
Millets, I filed an application, that is IA number 375 of 17, to vacate the ex parte order of 31/7/21. This was filed on, my lords, page 22.
375 of 17.
Yes, my lords.
To vacate order date 31/7.
No dates mentioned.
Correct?
Yes, my lords. Now, this application was dealt with. This was filed by me on 4/9/17, my lords.
After for vacation of order dated 31/7/17 on 24/9.
I think it is 4/9/17 at page 22. There's a remark of the tribunal, so I think that was the date. I'm not very certain about the date, but I'll give it to you, lordships. Then the tribunal passed an order, my lords, on 4th of September 2021.
21.
My lords. Tribunal passed an order on IA number 375 of 17 to afford
21.
I'm sorry, my lords, there's a typo error in my list of dates. I'm sorry.
Lordship, I just interfere. This interim order also is applicable before the tribunal, Lordship, under section 17. Under section 17 of this DIT Act, this interim order also applicable, Lordship.
Interior?
Interim
Interim
order.
Interim order.
Interim order.
But interior order also.
Interior order also applicable.
So, my lords, the tribunal basically issued notice to the bank, my lords, to file its objection. Thereafter, my lords, by the order dated 26/10/17.
No, 4/9/17 you filed that. Okay, that's over. Then
26/10/17.
10/17, yes.
Tribunal rejected my prayer to file written statement and recall that order of ex parte, my lords.
Okay. Rejected application. Right. Then after what happened?
Thereafter, my lords, the tribunal heard the matter, the main matter, on 5/12/17.
5/12/17. Heard. Then?
My lords, I preferred a review.
Heard? No, order the review against what?
Against the order dated 5/12/17.
Heard and finally disposed of.
No, reserved. Reserved for orders.
Heard and reserved.
Yes.
Then?
I preferred a review, my lords, on review of order dated 5/12/17. And, my lords, that was registered as RA number 1 of 2018.
No. When was the final order passed?
5/12.
How can you file a review against a reserved judgment? Like just heard and reserved.
My apologies. I'm sorry, my lords. The 5/12 is the final order.
Okay.
My apologies.
Judgment passed.
Judgment.
Okay. Ex parte.
Yes, my lords.
Okay.
So I prefer a review, my lords.
On?
1/2/2018.
1/2/18.
My lords.
Review file.
My lords.
Right.
And that matter gets disposed of on. Bank filed an objection to that on 14/9/18.
14/9/18.
My lords.
No, 3/7/18. See properly. 3/7/18. Reply given by the respondent.
I think something wrong here. Just of date.
I think, well, there is just a second.
Objection filed on?
Page 61, Lordship.
Just filed on.
Just give the dates at least under sequence.
My list of dates seem to be a little. The affidavit is affirmed.
Reply given by the respondent.
3/7/18.
18, Lordship.
3/7/18.
Page 61. Annexure 8.
I'm sorry, my lords. At page 75, it is 3/7/18.
Okay.
And, my lords, my review came to be dismissed on 30/8/2021.
After 4 years?
My lords.
Okay. Then?
Against that, my lords, we were before your lordships.
So 17 to 21.
When did we file it? Because I'll give the exact date on when the writ petition has been filed. 4th October 2021, my lords, the matter came to be filed before your lordships.
October 2021.
Well, at page 19, the affidavit is affirmed on 4th October 2021.
Okay. And after 21, it came up in 22, after 1 year. Because of COVID.
Well, I think that COVID was on that time.
Oh no, not 1 year, some few months. Yes.
I think the matter first came up before your lordship.
Okay, yes, then, yes, start. Then?
The issue here is, my lords, that with regard to whether even if the matter, my lords, by written statement is closed,
yes,
whether the matter can proceed ex parte against me, my lords.
Right.
Because the law is settled, my lords, even if the court
can
is,
take part, yes,
my lords, I can participate in the
yes,
proceedings. Now, that is not done, my lords. It is an admitted case of the order being passed without hearing.
Okay.
They cannot say, my lords, that I was heard while that order was passed. I'll take your lordships to the orders, my lords. The first order your lordships would find at page 21.
Yeah, 31.7, right? We got this page 21. And actually 1A.
Marriage.
Okay. Other counsel filed the final statement.
The counsel for the defendant number 1 to 4 has not filed written statement.
Now, before the 30 days time, correct?
Balance.
For written statement.
Balance.
Yes.
30 days extendable up to 90 days.
15 days.
30 days, where's the law?
Rule 12 was filing of written statement and other documents by the defendant by an applicant. It's page 37 of the Rule 12.
Yes.
The defendant may within a period of 30 days from the date of summons file 2 complete sets of written statement including claim of set-off or counterclaim, if any, along with documents on a form of a paper book. A copy of the written statement filed under sub-rule 1 will be served on the applicant. If the defendant fails to file written statement, his defense including claim for set-off or counterclaim under sub-rule 1, if any, within the prescribed period of 30 days, the presiding officer may, in exceptional circumstances, special circumstances to be recorded in writing, extend the period by such further period not exceeding 15 days.
15 days.
So that's where the whole mess started from. You couldn't file it within.
But I draw your lordship's attention also to section 22 minutes.
Section 22
of the Act.
Okay. Yes.
No, it says that the tribunal and the appellate tribunal shall not be bound by the procedure laid down by the CPC, but shall be guided by the principles of natural justice and subject to the provisions of this Act and rules. The tribunal and the appellate tribunal shall have powers to regulate their own proceeding, including places at which they have the sitting.
Yes.
Lordship, I refer section 19 of Rule 5. Section 19 of 5, sub-rule 5, section 5.
Of the Act.
Of the Act.
Yes.
Section 19, subsection 5, I think they want to refer to.
The defendant shall, within a period of 30 days from the date of service of summons, present a written statement of his defense, including claim. The same thing what is mentioned in Rule 12. Set of under subsection 6 or a counterclaim under subsection 8, if any, and such written statement shall be accompanied with original documents.
Please let him submit first, then we'll hear you.
Okay, Lord.
So therefore the only question which would have to be determined by your lordships, Millets, and my humble submission would be whether, Millets, the period as provided under section 19(5), which was read out, Millets, would be, Millets, mandatory or it would be directory. The same issue, Millets, which is decided, Millets. Section 19(5) and the rules, I think they refer to Rule
12.
Rule 12, Millets.
Yes.
So these are the two. This is the issue that would have to be determined, Millets, number one. The second issue, Millets, which in my humble submission would be of relevance, is that even with the closure of written statement, Millets, whether the right of examination, cross-examination, and Millets hearing, participating in the final hearing of the matter, would be available to me after closure of the written statement. My humble submission is, Millets, it is a right which is there. And
where's the judgment? What's that? Against, I think it's a judgment against Election Commission's Sarnam Singh or something that is, that even after one ex party also they have right. And yes.
So that would be the second line of argument, Millets. And the third and the most important.
But you didn't take part. Why? Taking part will be on account of even closure or yes, that
But I think those orders, unfortunately, I don't know if they're on record or not.
Yes. So the basic fact is that written statement you didn't file it. The matter was when was the original application filed? The 25 of 2017.
The original application
was filed when, and then how many dates you allowed? How was the time allowed? 25/17.
I have to assist your lordship somewhere.
Is it here in your pleading?
Here, my lords, it is not there because those other orders are not there.
When did you file it, Mr. Das?
Lordship, first it was filed in 2016.
Date?
Yeah.
And notice when it was accepted?
Yeah, notice first order was passed on 27/1/2017.
Once again.
OA original applications 25 of 2017.
Filed on 27/1.
27 was the first order.
Okay, just where do you get that from?
Lordship.
Where are you reading it from?
These are my learned senior's notes, it's not part of the record.
Okay.
Well, may I pray?
Yes, okay. Now you see, even with the closure, because whether you can be stopped from taking part in proceedings, right?
Well, may I only pray before your lordships? The facts I've placed before your lordships, like I've said, the arguments would be limited to only on those two issues.
Yeah.
We could probably have it on Monday, my lords.
You give authorities.
Because that,
and also your
Salem Bar Association would also have a bearing.
No, but the thing is that, see, this is a watertight act now, and like interference by writ court 226, 227 is really frowned upon now.
Lodge.
There are subsequent judgments Supreme Court said it not, because to make it efficacious, the recovery of debts. So that's one thing.
Recently, my lords, I had the occasion of, my lords, appearing in a matter arising out of DRT and from Allahabad, of course, my lords,
yes,
where the High Court had not interfered. That matter was carried in appeal before the Honorable Supreme Court. Supreme Court interfered in that matter, saying that in these kind of circumstances,
the issue that authority, see, in this case, it's a pure case of non-filing written statement.
Lodge.
Correct. Now, the only limited ground you have is that whether I could not have participated in the hearing, the final stage.
My lords.
Right. Fine. The
As
thing
a
is
matter
that
of
now
fact,
you have to show your conduct shows that you're not bothered, didn't file a statement.
The next
and
order
whether there's any substance in your second argument that we're not allowed to take part.
My lords, that is also the second order at page 25, if your lordship see, that is of some relevance here.
25.
My lords. Annexure 3.
Yes.
Lordships have it.
Yes.
Mr. B. Sharma has appeared on behalf of respondent number 1, defendant number 1 to 5, whose right of written statement cum evidence on affidavit is already closed. No one has appeared for the pro forma defendant number 5. The matter is proceeding ex parte against defendant number 5 already closed. Today is the date fixed for final hearing.
Yes.
The learned counsel for the defendants number 1 to 5 has filed an IA bearing number so and so for vacating the ex parte judgment passed on 31/7/17 and allowing them to file written statement come evidence on affidavit. A copy of the same is served upon the learned counsel for the bank. Learned counsel for the applicant bank has submitted that he will file written objection permitted the same for 2 weeks from today, and an advance copy of the same shall be served upon the learned counsel for the bank. So, on the next date of hearing, we did appear and we did apprise the court. The remedy available to me was to file an application for recalling of that order. That I have done, which ultimately came to be dismissed.
Right, on 26/10.
So it's not that, my lords, that after that order was passed, I sat tight on it, I did not do anything.
26/10? Yes, okay. No, of course, no. What I'm saying, after it was finally rejected, whether you took part at all in the proceedings, did you come there?
This first date we did, 14/9, I have demonstrated, my lords, we were present before the court. What I'll do is, my lords, if your lordships grant me a week's time, we can probably have a compilation of the entire order sheet.
No, not necessary, because the point is very short. Yes, just
we can have it on Monday.
Bring the authorities.
Monday with those two authorities. And like I've submitted, my lords, my arguments will be restricted to only those two grounds, because I cannot go beyond that. And of course, my lords, what fell from your lordships, whether this court should interfere in these kind of matters. I'll have to satisfy your lordships.
We'll list the matter on Monday for further hearing.
Main is item 44.
do it.
Yes, Mr. Shah.
My Lord, here the petitioner challenges the order of discharge, dismissal from service on the ground of my Lord, fake certificate. Fake certificate.
Where's the order of dismissal?
My Lord,
discharge?
Order of discharge, page 38.
Page?
Page 38.
38.
My Lord. In excerpt 8.
Ministry of Home Affairs?
My Lord.
No. 38.
38, my Lord.
Oh, okay, sorry. Yes, annexure 8.
My Lord.
Yes.
My Lord. Whereas it has been considered that the conduct of number such and such of 5th Assam Rifle who got enrolled on 13 September 2010 by submitting a domicile certificate dated 20th April 2010 issued by the officer of the subdivision officer Southwest Pargana West Bengal, mentioning as the resident of village such and such apartment Kolkata West Bengal, my Lord.
Kalikapur.
My Lord.
East. Yes, okay.
Kolkata State, West Bengal. Whereas Office of Subdivisional Officer, my Lord, Southwest Pargana, vide their letter number dated 27 September 2016 has informed that the domicile as mentioned in the para 1 produced by the NCO at the time of enrollment is not related to their office, my Lord.
Okay.
My Lord, not related to. I will hamper on that.
Not related to.
Not related to their office, my Lord. Whereas, my Lord, such and such was afforded an opportunity to show cause as to why his service should not be terminated on the ground of furnishing a false and incorrect information at the time of enrollment by Headquarters 7 Sector Assam Rifle letter number dated such and such on 1st September 2017 and received by him on 12th September 2017. Whereas number such and such of 5th Assam Rifle submitted his reply to the EBIT show cause notice by their letter dated 3rd October 2017, wherein said that the statement of the SDO South 24 Pargana West Bengal says that the certificate is not related to their office, but it does not say that the information contained therein is incorrect in any manner, that he has not allowed to cross-examine any person that he has got verification, and second time verification done the second time. Even
Prabhat Kumar Sharma didn't answer the question. Who is Prabhat Kumar Sharma?
Prabhat Kumar Sharma, my Lord, is a purported complainant. Purported. I am saying
purported. Can a complainant be purported?
My Lord.
How?
How, my Lord? Nothing. What is the complaint, my Lord? In the entire affidavit in opposition, the copy of the complaint has not annexed. What was the allegation against me? The petitioner. That has not been.
Nothing is there.
Nothing there. My Lord, that's why I am saying purported, my Lord.
Okay.
My Lord.
And even Prabhat Kumar Sharma did not answer question because of examination, and therefore witness, if any, is worthless, meaningless, and highly acceptable in law and cannot be used for termination of any person from service of such witness. That is your statement.
My Lord, in my show cause.
Right.
How? And whereas, in reply to the show cause notice, which are duly considered in the light of the documentary evidence
adduced before the court of inquiry. My lord, I will highlight that court of inquiry. The legal provision in respect of the cross-examination of and the findings as well as the opinion of the court, the reply has been found unsatisfactory and does not absolve the individual from the culpability of producing a false domicile certificate during the enrollment. Hence, my lord, he was dismissed from.
Yes.
My lord.
How many years had he served?
He has served, my lord. He was enrolled in 2010, my lord.
Okay.
18 years of.
Yes. Okay. Then,
my lord, challenging this, my lord. My lord, the petitioner.
Yes.
Filed a representation. He have mentioned the court of inquiry. Court of inquiry. That representation is at, my lord, at page 42, my lord. Annexure 12, my lord.
Yes.
My lord. Because that you give me the copy of the said court of inquiry, which is needed for redressal of, for approaching the competent court of.
Was that given to him, Dr. Mozika?
Later on, after issuance of the legal notice, man. I have annexed the.
After the discharge.
After the discharge.
2021, you filed. Why?
My
So
lord,
long after.
that's why I have been waiting because the court of inquiry. What was the finding of the court of inquiry, my lord? What is the against? What will be my ground to challenge before this honorable court, my lord?
Yes.
After that, my lord, I have issued the petitioner has issued a legal notice, that is at page 44, my lord, for grant of the court of inquiry.
Yes.
In absence of the court of inquiry, my lord, I am unable to approach this honorable court.
Yes.
And they provided me the copy of the court of inquiry.
After legal notice?
After the legal notice, madam. Legal notice was issued to the Secretary Ministry of Home Affairs, madam. Then thereafter they provided me. Less finding and opinion, madam.
Yes.
With the less finding and opinion.
With the?
Less finding and opinion. Means court of inquiry was there, madam. Means what is the opinion of the court?
Where's that? Where would he supplied you? Where's that?
That is at my lord, in their affidavit in opposition, my lord.
One second, I just.
My lord, sorry.
Page?
My lord, page 26 of their affidavit filed by the respondent authority.
Yes.
My lord, it was addressed to the council, my lord. Reply of the legal notice. Please refer the legal notice of such and such dated 19 January 2022 forwarded to this office unit. The copy of the court of inquiry, my lord, para 2, my lord. Less finding, opinion and recommendation in respect of the petitioner is forwarded along with the relevant exhibits.
Yes.
Of such and such. So why they are hiding with the opinion and of the court, whether the petitioner is blameworthy.
Findings, if the materials materials necessary, already relevant material has been given to you, then what is necessary?
My lord, if the
where's that report?
My lord, court of inquiry report. That's why I have called, I have craved leave of this Honorable Court to call for the Court of Inquiry's copies of the Court of Inquiry copy. For proper...
Where's the report? With you there? That's the entire thing?
This is the entire.
Let us see what is that.
Where I got that? I got from you.
See, you've got everything, the position, everything is here. Finding of the court 59. Exhibits. Where's the finding of the court?
Not there.
It's not here.
That's why it's less finding, and that's why, my lord, my prayer was to call for the Court of Inquiry, my lord. Copy of the Court of Inquiry.
Rambosi, you've seen this?
No.
The copy given to him?
We have not
26.
We call for the records.
So you just have a look, because if the index indicates finding of the court, opening of the court, he says it's not been enclosed.
But the rules say when the Court of Inquiry report is to be given, my lord, that will be minus opinion and findings, my lord. Only the statements, because the Court of Inquiry is something like 161 statement, my lord. There is no evidential value as such. It's only a fact-finding exercise, my lord.
Fact-finding, my lord,
based on that, some rifles force court.
Based on that Court of Inquiry,
after that, a record of evidence, my lord, and then the trial begins.
Summary of evidence, my lord.
Summary of evidence.
So you're summarily dismissed or discharged
without
after this?
Yes, ma'am.
With opinion that should be discharged.
I can place that, ma'am.
Strange case.
It appears, my lord, there was
not come against such a case, because usually when everything provided, what is there to hide?
Definitely, my lord. Based on that,
the rule itself says, my lord, that while giving the Court of Inquiry the opinion.
No, Court of Inquiry is not required. Actually, you keep all the materials. The one recorded against him, the deposition, so on and so forth. No, because this one does not go for a force court. That is what.
Yes, ma'am.
That is what. So it ended
there.
Not
required, because the rules in case of submission of fake documents and enrollment on the basis of such documents, my lord.
Look at the findings as to that's fake.
Wait, nothing. That's what, my lord.
That's why it's necessary for a court to say.
My lord.
Take down in the course of hearing, it appears that the records of the Court of Inquiry is necessary for perusal. Stop. When can you think? Done a DSI to produce the same on the next date.
2 weeks time.
Just after 2 weeks. Strange, because yes, we understand different stages, but if court inquiry is for this is a fact-finding thing. So, but on the basis of that, if the rule provides, you don't have to give the opinion as well. But at least the finding of the court inquiry, we have to see.
That's why, my lord, I have said that, my lord, I will highlight that Court of Inquiry, based on which the impugned order has been passed, my lord.
Yes. Okay.
46.
May I please, Lord?
Yes.
So, next minor promotion of the petitioner to the post of superior minor. So, during the pendency of this petition, my lord, I have been promoted, my lord. Only my grievance is regarding, my lord, the respective promotion, not a petition restrictive effect, my lord. With effect from the data promotion of the, my lord, respondent number 5. My lord, my promotion has been, my lord, when, my lord, the promotion has been, my lord, in place before the, my lord, Development Promotion Committee, my lord. They have not recommended because out of 5 SCR, my lord, the 1 SCR is below, my lord, than required, my lord. That is there, my lord. My lord. Thereafter, my lord, then when I was not promoted, I filed a request before the authority, my lord, saying that
if any adverse remark or anything is there, my lord,
communicate to me.
That has been not communicated. I have not getting an opportunity, my lord. That, yes. My lord. Thereafter, again, my lord, the respondent number 6, 7, 8, another
communicated to you after that? No.
No, my lord. No, my lord. Thereafter, my lord.
What is your prayer here at that time?
My lord, first is to was such as the impugn order by which the respondent was promoted, and the subsequent impugn order dated census promoting the private respondent to the post of subsidiary ignoring the seniority position. Second is promote the petitioner. That part is my lord. Okay, promote the petitioner with effect from 1/11.
So only this prayer number 2 survives, you say?
My lord.
Right.
That part is remaining, my lord.
Yes, where you plead? Where are pleadings with regard to?
My lord, the respondent, my lord, filed an affidavit, my lord. In the affidavit, my lord, they have taken a categorical stand, my lord. The SCR of 2016, my lord. Lordship may come to the affidavit, my lord. Filed by the respondent, my lord. The annexure 1, my lord. Page 13. Serial number, my lord, 8, my name appears, my lord. My lord. Next to me, my lord, Umesh Chandra Singh, he has been promoted, my lord.
Before you?
You
joined on enrollment 86.
My lord.
And this enrollment of this Umesh Chandra Singh, is he made party?
89.
My party. He party. He is represented.
Respondent number 5. Other 3, 6, 7, 8. My lord.
Is it appeared?
They have not appeared. Duly served, my lord. Affidavit is filed, my lord, regarding the service of the notice, my lord.
Okay, very good.
My lord. Then? Here, my lord, the serial number 8. You will also come to a grading, my lord. That for the year 2017, I got 5, my lord. That means average.
Where are you reading
from? Average, my lord. My lord, last column, my lord. The year-wise, my lord, gradation, my lord, grading. For the year 16, for the 17, in 17, my lord, the 5. It is required, my lord, above average, that means 777, my lord. So in another month here, I have been even 5, my lord. Page number 13, my lord.
Yes, no, 1 second. I can't make out. It's print very small. Yes.
Yes, my lord. Yes, my lord.
Okay, number 8.
Serial number 8, with right hand side, my lord.
Yes.
R, there 7, 6, 7, 5, 7, 7, 7. Because the 5 years SCR, my lord, as per 2016, my lord.
16 is R, 17 is recommended.
My lord.
Then in 20 is what? 7 means?
7
lacking.
Means, my lord, this is
scoring.
Above average, my lord.
So above for 16 above average.
My lord. And 17, 5. That is not, my lord, until unless I get up
2020
is not eligible.
2020 is what?
7, 7. All are 7, 7, my lord.
But it says not recommended to lacking ACR criteria. Is for the year 2020 not yet or recorded? Okay.
Recorded, my lord. Only because of that, my lord, they have not, my lord, promoted me, my lord. Lordship may come to the, my lord, the ACR.
So what do you want to represent against that 2020 is against that ACR 5? Against 17, you want to represent against that for reconsideration for prospective promotion?
My lord. So, my lord, the annexure 2, page 15, my lord. This is the 2017 SCR, my lord. According to them, my lord. This is from the with effect from the 1st September 2016. Yes, 15, my lord. Page 15.
Yes, September 16 to August 17.
August 17, my lord.
Yes.
So here, lordship may come to the, my lord, page 18, my lord. Page 18, my lord, the pen picture, my lord.
1 second.
The initiating officer, my lord, it's okay, my lord.
Yes.
But reviewing officer, my lord, this 5, my lord.
No, wait. Reviewing officer is 5.
My lord.
The initiating officer gives 7.
7, my lord.
Individual is physically fit and robust. He enjoys good command and control over subordinate and is dependable. Okay, fine. 7. Now, reviewing officer says physically fit. But why does he give 5? What are the reasons?
No reason, my lord, assigned. Though I have come to know after this affidavit, my lord. Even, my lord, this 17, which is a senior reviewing officer, my lord, that is a different.
I agree with the assessment of the reviewing officer, are also liberal.
Liberal is
IO, that means
assessment.
investigating officer is liberal.
That's why, my lord, that will not communicate to me.
Take down. Anything to say, Dr. Majika?
My lord, similar order in past, the previous order.
My lord, I have got an order. My learned friend was the petitioner in that case.
No, let's see what is that. My order only.
Similar order, my lord. But in this case, all 5 years were to communicate it. Here, only 1 year can be communicated.
Yes. Only in year 17, 16, 17.
16, 17.
Yes.
Actually, my lord, this 16, 17 also may not come also, because, my lord, they have said that has been become, my lord, high average, above average, my lord, because of, my lord, 7-pay commission, my lord. The 7-pay commission, from good to, they become all very good. Earlier it was 3 very good, 2 is good, is eligible for promotion.
After the only thing, your name, sorry, you're Mr.
I'm Sorania.
Mr. Sornia. It's like this now. The only thing is that they have to consider, notwithstanding under what are the gradings or the parameters now. The thing is that for lacking ECR and that relevant year, I mean 16 to 17, your promotion was not considered. Now they've given you promotion. Now your claim is to retrospectivity from the date respondent number 5, I mean 21, you should be promoted, right? So now your relief will immediately that allow me to represent against that particular period for reconsideration for my promotion respectively. That is all. Yes. We'll pass orders. Yes.
Sir, one legal put there, madam, because that year also to 17, otherwise I'm eligible if I argue like this on this way, my
yes, no, they will consider, but one thing when they consider, they'll consider whatever parameters are.
My lord.
We'll pass orders. Yes.
My lord. I love this, my lord.
Yes.
48.
You ready, Mr. Ongri?
Yes.
How long will it take?
May it please your lordship. Lordship, I'm just taking over this file, so.
So you're very sharp. No problem for you. You have 5 minutes. You get the report. I think you can argue.
I need to read your lordship.
Okay, you read slowly. Listen. You need to read. Just listen. What's the matter about?
This is regarding the promotion, your lordship, whereby I was rejected on the ground of relying on the office memorandum, in spite of the service rule is very much applicable.
Okay. Oh yes, Mr. B. Barasi was doing it. Yes. Mr. N.D. Shulai, learned AAG, submitted. He has just taken over the brief. He prays that some accommodation be given. Not objected to by Mr. E. Nongbri on behalf of the petitioners. When?
After 2 weeks,
Just a matter of 2 weeks.
Oblige, your lordship.
No urgency.
No.